Good. You're Robert Felix.
Yes, ma'am.
And come on up, ma'am. Let me get this pulled up here. Good. And let's see, this is 21-38610 and 21-38611. Mr. Felix is on probation in each of those cases. One for manufacturing or delivering a controlled substance and the other for felon in possession of a firearm. I received an administrative hearing from Ms. Shoppa Bradley, and in it, the request was to schedule it for a judicial review. So you were in custody and released December 18th. And the stipulation was that you have a GPS monitoring device with 0 tolerance. And it looks like there have been several issues with that monitoring company, that the battery either hasn't been charged properly. Looks like you were out past curfew. January 2nd, on January 3rd. Also, claim that you have unstable housing. But you're supposed to be giving the information of which of the addresses you're staying at to your probation officer each day. Is that correct?
Yes, ma'am.
So what's going on?
I really don't know what the address I'm staying at. Anytime I was out past curfew was because of work purposes. I was doing dashing. I gave her the receipts of proof for that. I have a job right now, Sparkling Image, putting on my seated
At where?
Sparkling Image Wash Depot, and I also DoorDash. I've been on this monitor for 5 years, Judge. I paid over $14,000 since 2021. And the monitors wasn't really hindering me doing what I need to do. And
Well,
like I make the curfews, I lost my house and everything. That's
well,
why
here's the thing. This was your, hold on. For you to say that this is a hindrance to you and an imposition on you does not bode well with me. Hold on. All right. You're on probation for obviously 2 serious felony cases. You have some criminal history, obviously, because you're on probation for an unlawful possession of a firearm by felon. I get that probation's not fun. I get that you have to do things you don't want to do. That's what happens when you commit felonies. So coming at that angle is not going to go well. Okay. You've had some issues. You were here and we required that monitor for a reason. And so I'm trying to look back and see, but I'm guessing the reason was that we had some issues with failure to show up, or what was the?
We initially did a judicial review there were some problems with the monitors and getting them to comply. We asked for a judicial review to see if he could get off of it, and he didn't show up for that hearing. And so that's what put him in jail. And then he did get out again. He initially had some trouble keeping it charged and everything, but once it was impressed upon him that this was not going to go away, of what he needed to take care of. The only problem is it's not feasible to have somebody that has unstable housing do a monitor, and while he's door dashing after 8 o'clock at night. I've checked his receipts. He does DoorDash. He's got receipts saying that he has, I didn't check every single one, Judge, but I've spot checked, and he is he's doing it. He's going to school, but this monitor is not acceptable way for me to try to supervise him.
Okay. So do you think it would be easier for him that you could actually supervise better without it?
I do.
Okay. All right, then. And here's the thing. It sounds like, Mr. Joseph, if you had showed up the other time you were supposed to be here, that was probably what was going to happen. And then I got mad that you didn't show up, and I'm going to make you keep the GPS. You see, the consequences just get worse and it could have been better.
I showed up last time. They sent me to a different courthouse in Port Arthur. I had the paperwork and everything. I've been screaming for help for years. I've been doing everything.
You've been coming to, you know what court you're supposed to come to when it's my date for you to come to court, because you've been
Right.
coming since you've been on the probation. So that's not, you know, if there's an issue here where you're supposed to be.
I just followed the last directive order. They sent me to put office that I had.
Who's they?
I had the info. I
So
can't.
here's the thing, things are going kind of well for you. You probably should quit coming up with excuses. Okay? Because it's probably one of my number one pet peeves. It's just to keep coming up. Just take the personal responsibility. Went to the wrong place, should have asked a bailiff. You know where the 252nd District Court is. You know the judge that's you're on probation for. So I'm going to, it sounds like you've got some really positive things going on and that you were in a bad place and you're working hard to get out of that. This isn't meant to make it harder on you, but you have to follow the rules and you have to show up, stay in touch. It sounds like your probation officer is willing to work with you through all of this kind of turmoil, with you not having a steady place to live. So take advantage of the fact that you've got a good one that's willing to work with you. Make sure you stay in touch with her. Let her know where you're staying. I know that's difficult because if you're changing places, you got to keep telling her, but keep doing all of that. You're going to be fine. Okay. So I'm going to I will allow the order that the GPS monitoring device be removed. That makes it all the more important though, that you stay in touch and she knows what you're doing, where you are and all of those things. Okay. All right, you're free to go. Thank you, ma'am. But yeah,
How did he do with his?
he didn't love it, but he wore them.
Well, he was happy with the result, I understand.
Very happy.
Good.
Good morning, you're Deshandra Joseph. And just a second to get this pulled up properly. Will your client waive the formal reading of the indictment?
She will, Judge.
We're gonna proceed on those. Go to judge.
Thank you. All right, Ms. Joseph, in cause number 24, DCCR 0708, the state's elected to proceed on the lesser included offense of a Class A misdemeanor assault from February 20th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? Speak up, please.
Yes, ma'am.
And are you pleading guilty because you actually did what they've charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Reynolds?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for 18 months deferred probation. There would be a $250 fine. Looks like there's a pending misdemeanor that this would run concurrently with. In addition, you would be required to enter and successfully complete an anger management class. And there would be no contact with Ruthie Duster. Do you understand?
Yes, ma'am.
And are you a US citizen?
Yes, ma'am.
State tenders number 1.
No objection, states one.
It's admitted. Is there any evidence that Ms. Joseph is not competent?
Not to my knowledge.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and probation for 18 months. You're ordered to pay that $250 fine and to follow all of those rules and conditions of probation, including entering and successfully completing the anger management class, as well as having absolutely no contact or communication with Ruthie Duster. That obviously means in person, but it also means sending messages in any way, social media, email, texting, whatever. Do you understand?
Yes.
If you do everything you're supposed to and follow all of the rules and conditions on this probation, this is an excellent opportunity because you don't have the conviction on your record.
Yes, ma'am.
And at the end of the probation period, if you're successful, the case will actually be dismissed. Never had this conviction.
Yes, ma'am.
The other side of that, though, is if you violate any condition of probation, you can be brought back into court and you could be found guilty and sentenced to anywhere in the range of punishment, which is up to 1 year in the Jefferson County Jail. Do you understand? All right, if you'll just, I've handed you the trial court certification. That shows this was an agreement that I followed, so you did waive your right to appeal. And if you'll just have a seat here in the courtroom, probation's gonna call you up to go over your paperwork in just a few minutes. She's sitting at that desk right over there, so watch for her to call you up.
Judge, I'm
Thank you.
sorry, if
Go
I may,
ahead.
before.
Yes, ma'am.
She's excused. It is my intention to follow the case down in misdemeanor court myself, having met with both of the complainants. Obviously, we would ask that no contact apply to Miss Roberts as well. That's Miss Doster's daughter. She was also involved in the incident and as a named complainant down the hall.
Okay.
There is a child custody issue, and I would ask that this court admonish the defendant that your no contact is specific to each and every aspect of her relationship with them, that it has been her mother who's been doing that transfer of the young man. I would ask, that she not be allowed to be on their property whatsoever. And I can get with the probation department about that with your permission.
Okay,
and
so
give them
Ruthie
information.
Doster is who to you?
Nothing.
Okay, and then the other complaining,
Miss Roberts,
say the name again?
Miss Roberts.
Roberts,
Mhm.
first name, do you know, what's her first name?
A-U-Y-A.
What is it?
Aya,
Oh, yeah, how do you spell it? Do you know?
A-U-Y-A.
And what's the relationship with Miss Roberts?
nothing. I'm actually in preparation with a lawyer, getting my son back. She's just a guardian of him right now.
She's a guardian.
She's a guardian of your son, so
Right,
that's the
That's her
relationship.
grandson.
Okay, so I'm going to also order that you not have contact or communication with her except through whatever appropriate means through attorneys or through the family court system, okay? There's programs you can use and apps where you can use something called the Family Wizard app. But if she's the guardian, then you've got to follow all of the rules that have to do with that. Get an attorney.
Yeah, I
Don't
have
have any contact or communication unless you have permission to do it in an appropriate way through family court.
Okay.
Okay? All right. Thank you, Ms. Malfino. Thank you. To have a seat and they'll call you up.
Thank you, Judge.
Good morning. Are you Jaron Crane?
Yes, ma'am.
And will your client waive the formal reading of the indictment in each case?
Well, Judge.
Judge, the court will recall that this is the co-defendant to Aline St. Clair, who pled a week or so ago, based on the conversation I had with the court about some issues with that case. It's my understanding that Mr. Crane has been on house arrest pending this plea, and I would ask the court consider that he remains on such, and at least until the PSI comes back. And you're confident that this is a suitable outcome.
Okay, thank you. All right, sir, in cause number 23, DCCR 1406, you're charged with the first degree felony offense of aggravated robbery from August 15th of 2023. How do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they charged you with?
Yes, ma'am.
You have your discovery certification.
I'll get them.
Just have them email and you can tell me. All right, sir, in clause number 23, DCCR 2233, you're also charged with the first degree felony offense of aggravated robbery from August 15th of 2023. And how do you plead to that charge?
Guilty.
Again, are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they've charged you with?
Yes, ma'am.
I have here on the tablet in each of those cases, some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Gertz?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreements that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached in each of your cases is for a 10-year deferred probation. There would be a $500 fine in each case. You would be required to follow all of the rules and conditions of probation. And would there be a dismissal in the evading? With your permission, can I write that in
Yes, Judge.
on the plea admonishments?
Yes, Judge.
So there would be a dismissal in clause number 23, DCCR 1082, which is the evading. Is that your understanding of the agreement?
Yes, ma'am.
Do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tender's number one in each case.
Objection, Judge.
It's admitted in each case. Is there any evidence that Mr. Crane is not competent?
None at all, Judge.
All right, sir, in each of your cases, I'm going to find that you entered your pleas of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of those pleas. Find sufficient evidence in each case to find you guilty. However, I'm going to reset your cases for sentencing so that the probation department can do an updated report. It'll give me more information about you, the cases, and kind of what we need to do to make sure that you have all the tools necessary to be successful on probation. So we'll come back later for sentencing. So on your way out of the courtroom today, you need to stop and talk to probation, and she's at that desk right over there. I am going to leave all the same bond conditions in place that you're under, and you've been, I think, following all of those conditions. Keep doing everything that you're supposed to between now and sentencing so that we won't have any issues when you come back for sentencing with me following these agreements, okay?
Yes, ma'am.
All right, we'll see you back at sentencing. Don't forget to stop and talk to probation. Justin Wallace with Mr. Lewis. Okay, so you've refused again.
I didn't refuse. I told him that I couldn't go. I
Well-
didn't refuse for the sake.
I'm just, there's no way that after a couple hours you can't go a little bit. So I'm gonna find Miss Paul, based on your, number one, that you told me that you smoke marijuana. You told the man in the back, the drug tester, that you smoke daily. And that you used alcohol also yesterday, which alcohol's, I'm not
Yes, ma'am.
so worried about unless you're driving, but
Mhm.
obviously using marijuana is a violation of the law, which means it's a violation of your bond conditions.
Okay.
And so let me see something real quick. Your current bond that you. I need to take a look at probable cause affidavit. Give me just a minute to get you more information about you and your case, and then I'll decide what to set your new bond at.
Miss West. Can I say, I know that I'm going to jail today, that's
Mhm.
fine. But I feel like I've been the victim in this and I have the proof. I'm just overwhelmed at this point with the whole situation.
Well,
Cause the girl is still harassing me.
have you called the cops?
No, but I have the proof of her going to my job recently. Letters from my job and her job.
All right, just hold on. You're gonna need to tell all that to a lawyer. That's. You still have that assault down the hall pending?
I have to go to that courtroom for the same person.
All right, so based on the limited information that I have.
Procedure. Jeez.
I'm going to again find that you violated the conditions of your bond and in cause number 25 DCCR 1752.
And just like that, bond jumps to $35,000. This is the flip side of courtroom discretion. Earlier, someone got a break. Here, the court heard daily marijuana use while on bond. That's a direct violation. Here's something important. Judges treat drug admissions in court very differently than street rumors. When you say it yourself, that's evidence. You think raising bond is the right move to enforce compliance, or does it just make things worse financially for someone already struggling?
Raise that bond to $35,000. A condition of that bond, if you make it, is that you have to have a drug patch put on within 24 hours of your release from custody.
Okay,
And obviously, if you get out soon, I'm going to assume that that drug patch will initially be positive,
okay.
but it should be going down. So it
Okay.
doesn't just test whether you're positive or negative, it gives me an amount.
Okay,
And if it's not going down, then that bond's gonna go up even higher. Do you
Okay.
understand?
yes, ma'am.
If you don't get the drug patch changed every 2 weeks like you're supposed to, some people say, oh, it fell off, and they don't just fall off, okay? So you need to make sure you have it on at all times, get it tested when you're supposed to, if you
Okay.
make that bond. Go back with the bailiff.
Okay.
All right, again, you are Carly Davis. And Ms. Davis, in clause number 25, DCCR 1451, you're charged with the third-degree felony offense of driving while intoxicated. From May 6th of 2023. And what that means in that case is if you go to trial and you're found guilty, the range of punishment is between 2 years and up to 10 years. And the potential for probation. And then in clause number 25, DCCR 1452, you're also charged with driving while intoxicated, third or more. This one's from February 10th of 2025. Again, if you were found guilty at trial, the range of punishments between 2 years and up to 10 years. And again, the possibility of probation. Do you understand?
Yes, ma'am.
And I have a plea bargain rejection here on the tablet that shows that the district attorney's office has made an offer in each of your cases. If you wanted to enter pleas of guilty for 10-year sentences that would be probated for 10 years. There would be the required 30 days in jail. And then there is, well, it's 10 days required. There would order, plea agreement is for 30 days in jail, a 90-day inpatient treatment with a drug patch, and those would run concurrently with a $1,500 fine in each case. Is that your understanding of what the offer is? And you have every right to reject that offer and have your cases set for trial. I want to make sure you understand what the possible consequences are if you go to trial and what your options are. And do you understand all of that?
I do.
And do you want to reject that offer and have both of your cases set for trial?
Yes.
All right, we'll get that done. Ms. Davis, I do want to make sure you understand that after today, I will not accept these plea agreements. Once your case is on the trial docket, it either goes to trial, both of them, or if you did change your mind and want to enter a plea of guilty, it would either be open to the court or to some different plea agreements. Do you understand?
Yes, ma'am.
All right, and you've requested, received all the discovery.
Yes, Judge.
All right, we'll get it set for trial. Stay in touch with Ms. DeLage and she'll begin preparation for trial.
Thank you, Judge.
Free to go. Thank you. Sorry, I didn't realize that's what all you had done.
I'm standing in for Mr. Gilmore too.
I'll sign those right now. Mr. Rucker, is he here?
He is here, Your Honor.
He's free to go. These dismissals have been signed.
Thank you, Judge.
Okay,
Good,
thank y'all both. Sorry y'all had to wait around for that. I just realized it was just. Good morning. Are you Gregory Sinclair?
Yes, ma'am.
And will your client waive the formal, I'll take it.
Yes, Your Honor.
Will your client waive the formal reading of the indictment?
Yes, Your Honor.
Mr. Sinclair, in cause number 25, DCCR 0471, you're charged with the state jail felony offense of injury to a child, elderly, or disabled individual from March 11th March 11th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they've charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with your attorney?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you will be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a 5-year deferred probation. There would be a $1,000 fine. You would be required to follow all of the rules and conditions of probation, including entering and successfully completing an anger management class, as well as complying with any of the rules of CPS. Is that your understanding?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
State tenors number 1.
No objections, Your Honor.
It's admitted. Is there any evidence that Mr. Sinclair is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you, your case, and then we'll come back later for sentencing.
Sorry to interrupt, Your Honor. The records, my file indicates this defendant has no criminal history if the court's inclined to waive this.
As long as you're satisfied with the conditions, based on the nature of the offense.
I am.
Okay, then I will waive the pre-sentence report, Mr. Sinclair. Again, find at this time sufficient evidence to find you guilty. However, I am going to follow the agreement that you made with the district attorney. And at this time, defer all proceedings and place you on probation for 5 years. You're ordered to pay that $1,000 fine and to follow all of those rules and conditions of probation, including complying with any safety plan the CPS has in place, as well as entering and successfully completing an anger management class.
Yes, ma'am.
If you do everything that you are supposed to and follow all of the rules and conditions on this probation, this is an excellent opportunity because you don't have a felony conviction on your record. And at the end of the probation period, if you have successfully completed it, the case will actually be dismissed. You'll never have a felony conviction. The other side of that, however, is if you violate any condition of probation, you could be brought back into court. You could be found guilty, and then you could go to the state jail prison for anywhere between 6 months and up to 2 years. Do you understand? Also, if you do everything that you're supposed to on this probation, it looks like this is something that's out of character. You don't have any history. I sign early terminations of probation all of the time. So if you get in probation, do everything you're supposed to, then after half or so of your probation, you could potentially get off early. I'm going to hand you the trial court certification that shows this was an agreement that I followed, and so you waived your right to appeal. You need to have a seat here in the courtroom. Probation, she's sitting at that desk right over there. She'll call you up when she's ready to go over your paperwork.
Okay.
Good luck to you, sir. Thank you, Ms. Simmons. And Mr. Clark.
Yes.
Good morning. Are you Christopher Stiles?
Yes, ma'am.
And in clause number 25, DCCR 0594, Mr. Stiles is charged with abandoning or endangering a child. And Ms. Simmons, what is the announcement?
Oh, yes, Your Honor. I know at the last setting, you did state this was going to be the last announcement. Mr. Gilmore is actually out sick this morning and not able to make it into court. So we're asking if we could have just a brief one week reset to give him time to talk to his client. I know he wants to talk to his attorney as well.
So we're not in court next week, so he'll get 2 weeks.
Yes,
Make
ma'am.
sure you make an appointment visit with Mr. Galmore so that we have an announcement at that next court date. So
Yes,
this will be the make sure the last.
Yes,
one.
Your Honor.
Okay, thank you. You're free to go.
Ronnie Grady.
Yes, Judge, can we make an announcement on Ronnie Green? It's an MTRP hearing. It's set for 11 o'clock this afternoon or this morning.
Yes.
That's correct, Your Honor. I don't know if you want me to briefly announce on that real quick.
Sure.
Again, Mr. Gilmore is out sick. He called me this morning. He's not able to get into court. He does have subpoenas out on that. I believe he made the court aware at the last setting that we're going to take a while to get back, and we have not got the return on those.
Two things on that, Judge.
Yes.
I have witnesses here ready for the hearing. They're
Well, and
coming-
if he's sick, I'm not
Well-
gonna, I mean, if you're sick, you're sick. If Ms. Simmons is being nice enough to come and announce, but Mr. Galmore could have just as easily called in and said, I'm sick and can't be in court. So I know you've got witnesses and that's frustrating, but we all have issues and I'm not gonna throw Ms. Simmons into the fire just because she's here announcing on that case.
Thank you,
So
Judge.
I will reset that. We'll look for an appropriate date in the next few weeks or so at an 11 o'clock hearing date as well. If you have any issues with getting witnesses on the date that I said it, Mr. Coleman, just let me know.
Yes, sir.
And I'm not sure what he's waiting on, but whatever it is, if it's
I'll
not
inform
here,
you.
we're gonna go forward
Yes, Judge.
on that date. All
I
right,
do believe that's all he has in court.
okay, yes,
Thank you.
thank you, ma'am.
Heavyweight now. Not that happen.
Good morning,
Good
you're
morning.
Desiree Kirk.
Yes, ma'am.
And Ms. Kirk's case is set for trial to begin with jury selection on the 23rd, and this is 24 DCCR 0518. And what is the announcement?
We're ready. Thanks for the trial, Judge.
All right, so it's like the last plea bargain rejection was back in September. And that was for a 10-year deferred probation. I do want to make sure you understand that after today, when I number the cases for trial, we'll not accept any plea agreements, if you understand.
Yes, ma'am.
And you want to go forward with your trial.
That's right.
Yes, ma'am.
Okay, so I'll number the cases tomorrow after docket. Mr. Kimler will have those the trial order. And so make sure you stay in touch with him and then we'll see you back on the 23rd.
Okay.
All right, free to go.
All right.
So you're Jose Colazo? And this is 24 DCCR 1084 and 1085. Mr. Colazo's cases are set for trial to begin with jury selection on the 23rd. And that's the announcement.
Judge, the state is tentatively ready, if I may. I know we're a couple weeks out. I've yet to hear back from a couple of witnesses, if I may, speak to the court maybe after docket or. Before tomorrow. I know, I need to let you know before.
We can be ready. Obviously, we are intending to be trying Austin Jones on the 23rd. There's,
Did they keep that court date over there?
I don't know. That was actually something I was gonna talk with you about at the break as well, but either way, we can be ready if.
All right, so what I'll do is I'm going to potentially number it for now. So obviously one of the older ones, I know that Ms. Malfino is getting kind of caught up on these cases with Ms. French. And so if you guys want to visit after docket, that's fine, or see what you can find out before tomorrow.
Yes.
And I'll number the cases tomorrow after docket. Mr. Plaza, make sure you stay in touch with Mr. Gertz so that you know when you need to be back on the 23rd.
Sure.
Okay, thank you. You're free to go, sir. Good morning, ma'am. You're Kelly McBride.
Yes, ma'am.
And will your client waive the formal reading of the indictment? Are we going on count one only?
Yes, you know.
And Judge, as part of this agreement, if the court is inclined to follow it at sentencing, she will enter a plea into the DWI that is associated with this.
Okay, thank you. Okay, Ms. McBride, in cause number 25, DCCR 0044, the state has elected to proceed on count one only. It alleges you committed the third-degree felony offense of obstruction or retaliation from December 9th of 2024. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Samuel?
Yes, ma'am.
Do you fully understand that?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a 2-year deferred probation. There would be a $500 fine, and you would be required to follow all of the rules and conditions of probation. Is that your
Yes, ma'am.
understanding? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. McBride is not competent?
None, Your Honor.
Right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back later for sentencing. It sounds like also between now and then, you guys will be taking care of that misdemeanor DWI.
That's correct.
So stay in touch with Mr. Samuel so you know when to go do that. On your way out of the courtroom today, you need to stop and talk to probation, and she's sitting at that desk right there.
Okay.
Okay, we'll see you back in
Thank you.
sentencing.
Thank you, Your Honor.
Yes, sir. Thank you. Good morning, sir. You're Bruce Hill.
Yes, ma'am.
And this is 25 DCCR 1348. Mr. Hill is charged with giving a false name or information, forgery of a vehicle registration. And Mr. Gertz, what is the announcement?
Judge, we're asking for a resetting on this. I think it's our first setting in person. But Ms. Malfino and I
There
are
was one in
trying to work
January,
out.
but go ahead.
I'm sorry?
So that looks like there was one in January.
It's our 9th.
Be careful when you say first, because I do have the list right here.
But I can't ever see the list, and you know how great my memory is. So nonetheless, we are actively working on resolving it.
Okay.
Ms. Malfino and I are.
All
And
right.
so we anticipate it will be resolved one way or the other.
And it looks like that was actually reset because of me. So maybe this is your first, even though it looks like you were hired back in November. I'll do a normal reset. Mr. Hill, make sure you stay in touch with Mr. Gertz. So that once he visits with Ms. Malfino, you guys can visit, and we'll get an announcement at that next court date. All right, free to go. Mr. Johnson, you have Dontrell Scott. Did you already apply for pretrial diversion or not? Okay. Okay. I'll do one more reset. You can get that letter in, and I'm gonna take care of all that. Mr. Scott, I'm gonna reset your case, just a normal reset, so Mr. Johnson can get that request in for pretrial diversion. If you're accepted, we'll figure out what to do. If for some reason you're not, you can visit with Mr. Smith and see what those alternatives are.
Yes,
Stay in touch with your attorney. He'll let you know when you need to be back.
yes,
All
ma'am.
right, you're free to go.
Yes, ma'am, we do.
And then you've got Tyrone Williams.
Yes, sir.
Things happen. Good morning. Are you Tyrone Williams?
Yes, ma'am.
And this is 24 DCCR 2242. Mr. Williams is charged with driving while intoxicated, third or more. Mr. Johnson's asking for a little more time to get with Mr. Smith. Make sure you got all the discovery though already,
Yes, sir.
video and everything.
We do that.
So make sure between now and that next court date, I'm gonna reset your case. Give Mr. Johnson a call, go in and visit with him so you can look at everything that he has received. So that when we come back at that next court date, we'll have an announcement one way or the other, whether it's gonna be taken care of with a plea or a trial, okay?
No, no.
All right, thank you. Y'all are free to go. Thank you, sir. Take care, Mr. Johnson.
Yes, sir.
Morning, you're Michaela Collier?
Yes, ma'am.
And this is 24 DCCR 0751. Ms. Collier's charged with aggravated assault with a deadly weapon. And what is the announcement? Actually, this is a motion. I'm sorry.
It's an MTRP announcement.
Yeah,
Go through it and I'll ask you, they're pleased to the allegations, either true or not true.
there's no agreement.
No. You gotta plead true or not true. Okay.
Ms. Collier, would you please raise your right hand? Do you swear affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, thank you. You can put your hand down, and will your client waive the formal reading of the motion?
So,
Ms. Collier, I have a motion to revoke your community supervision. Shows that you were placed on probation October 7th of 2024 for the second-degree felony offense of aggravated assault with a deadly weapon. And that was a 10-year sentence that was probated for 10 years. Is that correct?
Yes, ma'am.
It alleges that you violated your probation. Count 1 alleges that you committed the new offense of assault causing bodily injury October 17th of 2024 in Jefferson County, Texas. And is that true or not true?
Not true.
Count 2 alleges that you failed to report as directed by mail or online to the Jefferson County Probation Department for the months of January, March, and April of 2025. Is that true or not true?
That's true.
Okay. Count 3 alleges that you failed to immediately report to the probation officer your change of address as ordered. Is that true or not true?
Not true.
Count 4 alleges that you're behind in your court assessed fees as of June 6th of 2025. It was in the amount of $523. Is that true or not true?
That's true.
Did you enter your pleas of true to counts 2 and 4 freely and voluntarily?
Yes.
And did you plead true to those counts because they're actually true?
Yes, ma'am.
This is the danger zone of probation. She admitted to 2 violations, failing to report and unpaid fees. And legally, that's enough. Once a single violation is proven true, the judge has authority to revoke. But notice something critical. The judge didn't sentence immediately. She reset for sentencing. That means there's still space for negotiation or mitigation. This is where outcomes shift dramatically. Do they double down and fight the new charge? Or try to salvage what's left before witnesses take the stand?
All right, then I'm going to find counts 2 and 4 true, find sufficient evidence to revoke your probation. However, I'm going to reset your case for a sentencing hearing. Mr. Nicholas, does the state intend to bring witnesses with regard to that new offense?
yes, I do.
So we would probably need a little extra time. We will set this, I'll get an updated pre-sentence report, and we'll set this on a date when we have time for some witnesses. I want to make sure everybody understands that after today, I'm not going to accept a plea agreement at the last minute. If the state, just like I said the other day, if the state goes through or anybody goes through with getting witnesses and having them here, it's not the time for negotiation. So if y'all want to negotiate, now's the time. Otherwise, we'll have a hearing and I will determine whether or not those other allegations are true. And then I will determine what sentencing is, if any. Okay.
Understood.
All right.
Thank you.
You're free to go. We'll see you back at the sentencing. Good
Morning.
morning. Good morning. Good morning, sir. You're Sammy Morris.
Yes, ma'am.
And Mr. Morris was previously in court entered a plea of guilty in cause number 25 DCCR 0242 to the third-degree felony offense of unlawful possession of a firearm by a felon. I've received that pre-sentence report. Has everyone had an opportunity to review the report?
I have. Yes, I have.
Any additions or corrections?
No.
Nothing to say, Your Honor.
All right, Mr. Morris, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time, follow the agreement and find you guilty of unlawful possession of a firearm by a felon. Sentence you in accordance with that agreement to a term of 10 years in prison, but probate that, and you'll be on probation for 5 years. You're ordered to pay the $500 fine and to follow all of the rules and conditions of probation. If you do that and follow all of the rules, then for all practical purposes, your case here in court is over and you'll be able to serve that 10-year term while you're out on probation. The other side of that, however, is if you violate any condition of probation, you can be brought back into court, your probation revoked and facing that 10-year sentence that you just agreed to. Do you understand? Speak up.
Ms. Moore.
I'm handing you the trial court certification that shows this was an agreement that I followed, and so you waived your right to appeal. And I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Obviously, you know this at this point, but I'm required to read it to you. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Adams. All right. If you'll just have a seat here in the courtroom, probation is going to call you up to her desk when she's ready to go for your paperwork. Good luck to you, sir.
Thank you.
Yes, sir. Thank
All
you.
right.